All right. Thank you, counsel. We appreciate you appearing by video oral argument today and want you to know that this is a work in progress. We've learned a whole lot about it in the past few weeks and we're continuing to learn about it, but we appreciate you participating in it and allowing us to keep the case flow going. Take just a moment and introduce the panel and make sure everybody understands our process. But your panel this afternoon will be Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Momentarily, we'll call the case. The appellant will have 15 minutes to make its oral argument. You may reserve up to 5 minutes of that time for rebuttal time, but please request that from the court after you've introduced yourself and before you begin your argument. It's my understanding that we have two appellees and that they've worked out an agreement and negotiated that with Mr. Hibner so that they can share their time, and that's okay as well. We appreciate Mr. Hibner being the strategist behind all this and making sure that everything's going well. And we appreciate the AOC and its technology staff in making all this possible. So, Mr. Hibner, if you'd call the case and we will proceed.
Debra Smith et al. Versus Ronnie Outen, MD et al.
All right, we will hear from the appellant.
Yes, Your Honors, good afternoon. My name is Eric Miles, and I represent the appellant, Dr. Ronnie Outen, in this case, and I would request 5 minutes for rebuttal.
All right, sir, you may proceed.
All right, may it please the court. This court should hold that a pharmacist cannot certify a good faith basis to sue a physician because he is not qualified to opine on the standard of care of a physician, and he is not permitted by Tennessee law to render a medical diagnosis. Next, this court should hold that a statement supporting a certificate of good faith must contain language that is consistent with the requirements of TCA 2926-122 for the issuance of a certificate of good faith. Finally, this court should hold that the witness who signs a statement supporting a good faith certificate must review sufficient information, including the pertinent medical records, before attesting to a good faith basis to maintain an action against a physician.
Miles, what's the standard we use here?
This is a de novo standard, Your Honor. I believe that's been set forth in the Kirby v. Hawes decision that we cited, in which it was analyzed whether a certificate of good faith was determined to be compliant. The trial court had determined that the certificate of good faith was not compliant and was not supported by an appropriate statement. The trial court was overruled by the Court of Appeals in that setting, in a much different factual setting than this one, and did so on a de novo standard.
Okay, and let's talk about the evidence the trial court had before it. Did it conduct an evidentiary hearing, or was it just based on affidavits and the record? Tell me the process that was utilized here.
Yes, sir, Your Honor. So essentially, when summary judgment was granted for Dr. Outen, we filed a motion requesting the court to require the Herndon defendants to produce the certificate of good faith statement. That was produced voluntarily, at which time we filed a motion asking the trial court to deem the certificate of good faith statement out of compliance with Section 122. And then if they rendered that decision, to then award sanctions, presumably following a sanctions hearing. From that point on, we simply briefed the matter and relied on the evidence in the record, and then had an oral argument as you would with a standard hearing, standard motion. So there was no evidentiary hearing per se.
Okay. You may proceed.
Okay, thank you. In this case, the statement supporting the certificate of good faith fails in all three of the respects I mentioned at the beginning, because a pharmacist is not qualified to render the opinions required by TCA 2926-115, which is referenced by Section 122, because the statement in this instance, even if Mr. Herndon was licensed medical doctor practicing in Tennessee or a contiguous state during the year preceding the care at issue, the statement itself fails to meet the requirements of the language set forth by Section 122. And finally, it is clear both from Mr. Herndon's statement and what was learned in his deposition after the fact as to what he had not reviewed even at the time of his deposition, that Mr. Herndon based his statement on essentially no information other than an allegation in the complaint. Leitner has made much to do about the ability of the Herndon defendants, and Mr. Herndon in particular, to rely on an allegation in the complaint. But what has not been addressed by Leitner is the fact that nowhere in the complaint does it state that Ms. Smith suffered injuries as a consequence of a direct cessation of mirtazapine. What she states in her complaint is a general allegation of injuries. So the element of causation is wholly uncovered by the complaint, which means that even if Mr. Herndon were a competent medical doctor, competent to render the opinions against another physician, he did not ever have before him any information to establish a good faith basis to determine that this patient more probably than not suffered an injury as a result of the alleged negligence. So we submit, Your Honors, that this is a wholesale failure to comply with 122 because it was signed by someone who is not competent to render the opinions. The statement itself does not comply with the language requirements of the statute. And the third component, the witness did not rely on information pertinent to the matter. What Herndon wants you to accept, or Leitner in this case wants you to accept, is that a plaintiff must submit a certificate of good faith based on an expert's review of medical records, but a defendant asserting fault need not look at any medical records. They can just rely on the statement of an attorney, for example, a general allegation in a complaint. That is inconsistent with the case law with respect to the enforcement of this statute, and it is inconsistent with the legislature's intent when enacting this statute. Under Leitner's analysis with respect to Mr. Herndon's ability to testify as it relates to Dr. Outen, there are numerous scenarios that fly in the face of Tennessee law in the body of healthcare law that we have, healthcare liability law that we have. Under their analysis, for example, a surgical assistant could provide a certificate of good faith statement against a neurosurgeon because he has handled instruments in an operating room during brain surgery. A radiology technician could lay the foundation for a lawsuit against a radiologist because she operates a CT scanner. Or entering the world of pharmacy, a licensed practical nurse could support the filing of a case against a pharmacist because he calls in a doctor's prescriptions to the pharmacy. That is simply totally inconsistent with the legislator's intent when they enacted 122, and there is no case law in Tennessee having ever found any of the scenarios or anything like the scenarios sufficient to allow experts of that ilk to testify against the people that were referenced in those scenarios. The examples are endless of how this could be carried out. And our position in pursuing this appeal is that allowing a statement such as the one signed by Mr. Herndon to form the basis for a lawsuit against a medical doctor, which is exactly what happened here, renders Section 122 meaningless because there is no law that finds in Tennessee a pharmacist competent to render an opinion on the standard of care for a physician. There is no law finding a pharmacist competent to render an opinion on medical causation. And in this instance, the statement itself fails to address numerous components that are a requirement of the statute. And when you look at the statute, it actually is fairly intricately drawn. Section 122B specifically addresses what the requirements are with respect to the signing of a certificate of good faith. And both requirements under B1A and B1B reference 2926.115, which is the framework all healthcare liability actions in Tennessee rely upon. 122 B1A and B do not parse out sections A or B of 2926-115. They reference the statute in its entirety, which means we must turn to 2926-115 and analyze that statute. Section A of 2926-115 sets forth what must be established in a healthcare liability action. That entails proving the standard of acceptable professional practice applicable to the profession and the specialty thereof, if any. So that is a two-layered approach. Number one, the profession. The standard of care in this profession was medical doctor, the medical profession. If there was a specialty, then the witness must also be competent to testify as to that specialty. In this instance, Dr. Outen is a family practitioner. Next, it must be established that the defendant acted with less than or failed to act with ordinary and reasonable care. And finally, as a proximate result of the alleged negligence, there must be an injury. No one is competent to establish those requirements unless they were licensed and practicing in Tennessee or a contiguous state during the year preceding the care at issue in a profession or specialty which makes their opinions relevant. In this instance, Mr. Herndon is not a medical doctor. He is not a family practitioner. The mere fact that he might be competent to testify on some issue in the case does not lend his testimony sufficient under 122 to meet the burdens established by that statute as referenced to 115, which sets forth the entire framework for the statute. By signing a statement and implicating Dr. Outen in this action, Leitner took Dr. Outen on a litigation ride that was not necessary and never should have occurred. And that is why we believe the certificate of good faith should be found non-compliant and Leitner should be sanctioned. Thank you.
Thank you. You've got your rebuttal time. We'll now hear from the appellee.
May it please the court, I'll be taking 30 seconds and then yield the remainder of the time to the third party appellee. My name is Minton Mayer and I represent Stephen Herndon and Herndon Pharmacy. The matters set forth in our very short brief and argument establish our position, and that is that all issues regarding Herndon Pharmacy and Stephen Herndon have been resolved. He voluntarily produced the statement, as it was mentioned, voluntarily paid the discretionary costs. And as to the pertinent issues before the court, we would suggest that Mr. Herndon submitted a statement in favor of a affirmative defense. The attorney and third party appellee was the gatekeeper and had the sole discretion and right to include that affirmative defense and did so. We hereby yield the remainder of our time to the third party appellee.
Thank you.
Please the court. I'm Suzanne Marsh and I'm here for the appellee Bruce Gill and the firm of Leitner, Williams, Dooley and Napolitan. We request that this court affirm the trial court's denial of sanctions. At the heart of this matter is whether the attorney for the original defendants should be punished for asserting a Rule 8 affirmative defense of comparative fault in a healthcare liability case supported by the sworn statement of his defendant client, a licensed pharmacist. The question before the court is the sufficiency of an attorney statement of good faith under 2926-122. Now, Your Honor, one of the questions that was asked earlier on is what should the standard of review be? Respectfully, I see that Kirby versus Hawes, the unpublished decision, says that it should be a de novo review. Most of the case law that I have read, if not all of the case law that I have read on an attorney sanctions matter, has been addressed under an abuse of discretion standard. And I think that would be appropriate in this area as well. I don't find case authority that supports an abuse of discretion standard head on that way, but I don't find case authority published that addresses the issue of attorney sanctions in the context of a healthcare liability lawsuit, with the exception of the Akers decision, which was very clear because the pro se plaintiff in that case did not have a signed statement from anyone and signed the certificate of good faith on her own. So I would suggest that that was a clear situation for the award of sanctions. Your Honor, in looking at the case, I would suggest that the starting point should be the defendant's form for the certificate of good faith. We argued in the court below that the administrative office of the courts gave us as attorneys a plaintiff's form and a defendant's form. The defendant's form has two options on it. Now, rightfully, in our instance, our client, Mr. Gill, selected option number one, attesting to the fact that he had consulted with a competent person, a competent potential expert who had signed a written statement setting out the elements of Section 122. Part two of the form, though, that the administrative office of the courts has prepared for attorneys says that you can consult with one or more and that you believe they're competent. And that person may, and you may check off on that saying that there are facts material to resolution that are unknown and cannot be ascertained. And that would be sufficient for an attorney good faith certificate. If that is the standard and that is the form that is given to us, then I'm going to suggest to the court that the standard for looking at what an attorney does should be a due diligence standard. And it should not be a standard as far as whether or not the expert later meets the burden of proof or the expert testimony is later competent. The second point, Your Honor, is that the Herndon statement itself meets the basics of Section 122. If you look at Section 122B and you look at what the witness is supposed to have said, the witness must be competent to express an opinion about the case and believe based on, for the defendant's form, the information reviewed, which does not say medical records, and there is no description of how much is enough in the way of the sufficiency of what the person making the underlying statement must have reviewed. Now, Mr. Herndon's statement is contained in the trial and in the record at volume 2, beginning at page 159. He sets out that he is licensed, that he has acquainted himself personally with the allegations of the complaint, as well as the injuries as claimed in the complaint as a result of the consequence of taking the medication. He says that he operates a pharmacy and that he's familiar with the standard of practice, and as part of his licensure, he is familiar with the use and indications of prescribed medications as well as side effects. He also says that tapering off of this medication is appropriate rather than immediate cessation. And as a consequence, providers need to understand the adverse effect of immediate cessation of mirtazapine. And in this instance, he says that the complaints of this plaintiff as asserted and as alleged meet up with what you would expect from a person immediately ceasing this medication. He concludes by saying, based on the foregoing, it is his opinion within a reasonable degree of certainty, he says pharmacological certainty, that the immediate cessation would have caused or contributed to her injuries given the similarity of her alleged injuries and the side effects for the immediate cessation of the drug. He says it is further his opinion that the immediate cessation caused or contributed to the plaintiff patient's injuries and that they were therefore caused by the actions of her treating physician. To that end, it is his opinion within a reasonable degree of certainty that the acts or omissions of Dr. Outen were sufficiently negligent to give rise to the plaintiff's injuries. Now, at face value, the certificate signed by Mr. Gill meets up to the requirements for what an attorney is to do. The statement signed by Mr. Herndon is a signed written statement that essentially tags the basis of what's expected in Section 122 at Part 2 for the defendant's certificate of good faith. So in this instance, the next thing that I would suggest that the court should look at is the affidavit of Mr. Gill, because the affidavit of Mr. Gill establishes that he in fact consulted with Mr. Herndon. He went over the allegations in the complaint with Mr. Herndon. He also states that he has never received any sort of Rule 11 sanction in the past. He states at paragraph 8 that when he received the suit papers, that he contacted his client, that there were not authorizations at that point that allowed him access to Dr. Outen's records, but prior to filing the answer, Mr. Gill met with Mr. Herndon and they reviewed the allegations in the complaint and the pharmacy records as the available records. They discussed the elements of the cause of action. They discussed the potential defenses and explanations for the lawsuit. They discussed the allegation that Dr. Outen told the patient to immediately cease taking mirtazapine, as that is asserted in the complaint. Based on this discussion, they outlined the defense position relative to what they knew at that point in time. Mr. Herndon signed the written statement. This is documented in Mr. Gill's affidavit. He prepared the answer, that is, Mr. Gill prepared the answer to include this affirmative defense, and he signed and executed the answer, and as well as the attorney good faith certification. Now, at this point in time, this was for the filing of an answer, the initial pleading on behalf of a defendant in a lawsuit. I would suggest to the court that the standard should be a due diligence standard. And in Jackson versus HCA Health Services, the court upheld the constitutionality of Section 122 and said that the burden that is being placed on a plaintiff in a healthcare liability lawsuit is essentially a due diligence standard. And the way that you measure that is by looking to see if there has been an attorney certification of good faith, and if there is, the underlying signed written statement complying with Section 122. And in this instance, I'm going to suggest to the court that what is in the record supports what is required of the statute, especially given the defendant's form that the administrative office of the courts has given us. The next point, Your Honor, filed in the trial court were the scope of pharmacy practice rules. And there's a discussion in our brief about the body of case authority and what is expected of a pharmacist. I know there's been much made of the idea that if you allow this to go by without sanctions, we'll have certified registered nurse anesthetists testifying in bad baby cases or RNs testifying about surgical mishaps. And I don't think that there's that kind of fear, because you still have to go back and say, what is the core of the lawsuit? The core of this lawsuit is the intersection between what is expected of a pharmacist and what is expected of a medical provider, of a physician. And in this instance, that's where Mr. Herndon and his scope of practice has been expanded. So within our brief, there are a number of cases where in criminal and in civil matters, pharmacists have been permitted to testify as to prescribing patterns, side effects of medications, levels of intoxication, what might be expected as a side effect of a medication, whether or not a driver would be under the influence given a medication. All of those things would appear to encroach upon what would be traditional medical physician testimony, but has been permitted as testimony of a pharmacist. In fact, a pharmacist has a duty to warn a physician if there is a known interaction or a danger of which the pharmacist is now aware. In a recent case that just came out a few weeks ago, a pharmacist is not permitted to stand behind the product's liability seller shield and must go forth and participate as a healthcare liability defendant without the benefit of the product's liability seller shield. So in this instance, my suggestion is that the scope of practice for a pharmacist, as outlined by the rules and regulations that were filed with the trial court, establish that a pharmacist is part of the patient care team. They are directly involved in patient care. We know that they are no longer just behind the counter. They provide vaccinations, they provide counseling, and in fact, they can be found liable for failing to warn a patient of side effects and of dangerous aspects of taking a medication. We know that's part of the body of case law. Also filed in support and the trial court level is the documentation from the PDR and the FDA package insert that supports our client's position at the trial court level that mirtazapine is meant to be gradually ceased, that a tapering is the way that you stop this medication. And that's what fits this case into a situation where a pharmacist has opinion and has knowledge and experience and education that is relevant to the issues and the lawsuit, and for which the pharmacist would be permitted to testify. The next point, Your Honor, Section 115, 29, 26, 115, A and B. Section A is the burden of proof for a healthcare liability claimant. Section B has been pulled apart from that. It exists separately within the code section, but the Shipley decision from the Tennessee Supreme Court explains that competency is what is defined under Section B. And again, I would suggest to the court that when there is a decision to be made about competency of a witness, that is an abuse of discretion standard. That's a 702, 703, Section 115, Part B discussion about whether or not a witness meets the competency requirements is reviewed on an abuse of discretion standard. And in this instance, Mr. Herndon and what he could offer the court in terms of his education, his experience, his knowledge, and the scope of practice for the practice of pharmacy would be relevant to the issues. And that's what section 115B discusses is the person qualified because they have a license? Do they have a license in Tennessee or in a contiguous state? Were they practicing in Tennessee or in a contiguous state in the year prior to the alleged negligence? And do they have an opinion about issues that are relevant to the case? Now, otherwise, we're in a situation where before you file your lawsuit or before you file your answer, you would need to have all of your burden of proof met. And that is not what the statute has intended. And that's why the due diligence standard would make sense for attorneys when they're filing a lawsuit, the initial pleading, or when they're filing an answer.
The trial court seemed to rely upon a finding of no bad faith here. How does that apply in this situation, or does it?
Your Honor, I think it makes sense because if you're living in a world where you are looking and attorneys are looking at the standard of what is a good faith pleading, that's a due diligence pleading based upon your investigation of the facts, the state of the law as it is, and whether there is a reasonable extension of the law that you can argue, something along those lines. So it makes sense that if you do not have a finding of bad faith, that you may have a finding, I guess, of something that would be neutral, which is where I think Judge McGinley would find himself in this, would be you could have done better. You could have had 3 experts lined up on each element of a plaintiff's cause of action or a defendant's allegation of comparative fault. But there is no bad faith if what you have filed is supported by the facts, supported by the law, and is sufficient based upon the due diligence that you've had the opportunity to undertake at that point in time. So I do think that a bad faith—
You have to have a finding of bad faith before sanctions can be awarded?
I don't think that that it would have to be a strict finding of bad faith. I think Judge McGinley in this instance found that there was no bad faith. I think that is an area of the law that has clearly not been developed because there's been very, very few cases. Most of the case law has been on the pre-suit, HIPAA, the letter, and all of that. So, Your Honor, I do believe that in this instance, Judge McGinley's finding was correct, that Mr. Herndon's statement is adequate, Mr. Gill's certificate of good faith complies with the statute, and the denial of sanction should be affirmed.
Thank you. Mr. Miles, we'll hear from you in rebuttal.
Yes, Your Honors. Let me jump back briefly to the standard of review question. I want to first note that in their response brief, the appellees acknowledge that the standard of review is de novo. The Kirby case, the appellate court overturned an award of sanctions, and they did so with a de novo review. This is not an abuse of discretion because we never arrived at the court determining the sanctions to be awarded. This is an issue of statutory construction. Next, I want to attack—
Hey, let me pose you a question then.
Yes, sir.
Assuming the trial court found that the certificate was non-compliant, is the trial court required to award sanctions?
Yes, the trial court is, because of the word shall in the statute. The Myers Court from the Tennessee Supreme Court has clearly established in a very detailed analysis under a principle of statutory construction, the use of the word shall in sections 121 and 122 is mandatory and makes those things that follow the word shall in that statute mandatory. In this case, if the court determines that the certificate of good faith is non-compliant, it shall award sanctions. Now, the court is given discretion, I believe, to determine what those sanctions may be, with a couple of exceptions. But a finding of non-compliance results in an award of sanctions, period. Does that answer the question, or at least touch on the question?
Go right ahead.
Okay, thank you. I want to briefly talk about this argument that was made by the appellee related to the statement. Mr. Herndon's statement itself is non-compliant. I want to point the court to the Akers case, which Ms. Marsh cited, and I would point your honors to page 8 of that decision. In analyzing the statement that the plaintiff intended to rely upon in that case, and this was a pro se plaintiff, this was not an attorney, and the court put the burden on the plaintiff, who is not a lawyer, to meet the requirements of this statute, and they held that the dictated notes that were not compliant contain no representation that the witness is competent under TCA section 115 to express an opinion, nor a representation that he believes there is a good faith basis for maintaining an action consistent with the requirements of section 115. The idea that you can read 115 and divorce section B from section A is incorrect. Section B explicitly references section A. So we look to Mr. Herndon's statement. Nowhere in the statement does Mr. Herndon say that he is competent under 115 to render an opinion against Dr. Outen, a medical doctor. He doesn't address competence at all other than to tell us that he's a pharmacist who dispenses medications. He doesn't order medications. He doesn't order.
We have a finding here by a trial court or by the court taking the evidence that in fact the pharmacist was not competent to render an opinion in this particular situation before we can go further.
I believe that the first question in this matter before we analyze the statement itself is whether or not a pharmacist can fulfill the requirements of section 115 sufficiently to give a good faith statement to support a lawsuit. And if a pharmacist is unqualified as a matter of law to set the standard of care for a physician, and if a pharmacist is unqualified as a matter of law to establish causation, then he cannot be competent under the framework established by 122 and 115, which is referenced in 122, to establish a good faith basis to maintain an action against the medical doctor. So I do think we have to consider those things. And if we don't consider those things, then there are very few scenarios where a good faith certificate statement would not be sufficient.
So in this case, though, we do not have a finding by the trial court that the pharmacist was not competent to render an opinion, do we?
I'm sorry, I think I may have misunderstood your question. I'm not sure, Your Honor. I think it's unclear. His holding was it would have been better practice to have a statement signed by a medical professional. So that tells me that he acknowledges that this was not a medical professional and that it should have been, but there was no bad faith. And since I'm running out of time, I want to address that very briefly. Bad faith is not the standard. It's a certificate of good faith basis to maintain an action. The statute does not look at whether or not the attorney is doing so in good faith. The statute is looking at whether a competent witness has certified that there is a good faith basis. The bad faith, the good faith, the no faith of the attorney is of zero consequence in analyzing the statement. And again, we submit that this statement is not compliant with 122, and we appreciate your time today.
Thank you, counsel. We appreciate your argument. We again appreciate you participating in this Zoom oral argument. We will endeavor to get you an opinion at the earliest possible date that perhaps resolves this issue. Again, we want to thank Mr. Hebner and the staff of the AOC for putting all this together. I believe that concludes the call of the docket for today, and we will stand in recess until the further call of the docket. Mr. Hebner.
This honorable court is now adjourned.
Thank you, counsel.